Click the like button, share and subscribe. It's free.
Just put yourself in the position of the panel, or you yourself. Perhaps 8.7 million rand is not so much money to council these days. But imagine, I'm sure I'm being facetious. Imagine you had lost 8.7 million rand.
Let me not respond. No, Justice Rogers. I mean, this is unfair, actually. I know that it's not, but it's really unfair in a matter of this public importance to make a joke like that and then to pass it on.
Let me then continue. 8.7 million rand, if, just as a matter of common sense, if a person loses 8.7 million rand, they would want to know who the investigating officer is and has it been reported to the police. Is there a case pending? And it's common cause that there wasn't.
Yes. But what is the question then for the issue that I'm dealing with?
I'm trying to just see the totality of circumstances.
Yes.
Then we have, and the panel paid a lot of attention to this, the source of the foreign currency, because it did, in regard to charges 2 to 4, it was not merely the fact that there wasn't a report to the, under the Prevention of Corrupt Activities Act, it was, the finding of seriousness was that that was a deliberate decision because the president was wanting to keep secret the source of the money. That's the background to where the panel was coming from. Now, in that context, it seems to me it was the president's version, based on what Mr. Ndlovu told him, that an unknown person, who is then identified as Mr. Hamas, comes to the farm on Christmas Day, just happened to be carrying in cash $580 million, $580,000.
Yes.
Yes.
Yes, and then
he concludes the transaction not with the farm manager, not with the man who runs the buffaloes, Mr. von Willich. He strikes a deal to buy 20 buffalo from the lodge manager.
Yes.
And hands over $580,000 and gets this receipt that we've seen. And then the buffaloes stay on the farm and are never taken.
Yes, I'm still trying to work out where, in relation to the members of the National Assembly, the criticism is.
Well, if there was sufficient evidence of the various matters I'm putting to you, then one might say that the independent panel could legitimately come to the view that in relation to charges 2 to 4, there was sufficient evidence of serious misconduct, sufficient in context to be tested for veracity, not sufficient to convict, but sufficient to go to an impeachment committee. So that's what their function is.
No, I submit no, because they did not actually make that finding. What would actually happen if we got to where you are, Justice Rogers, is you would have to fundamentally rewrite the conclusions of the panel. That's why I was asking the court to have regard to there are actually several pages, 128, paragraph 204, 137, paragraph 238, 138, paragraph 239, 145, paragraph 264. It's so clear in those paragraphs that what they thought they were doing is to establish prima facie evidence based on information.
Well, we will read the whole report. You'll recall, I think, the acting Deputy Chief Justice put to, I think it might have been to Mr. Budland, certain earlier paragraphs which appeared to indicate what the panel understood. But I accept, bear in mind, the panel here says, even after hearing the President's version, taking into account what he says, this is not just yet unanswered evidence. Together with his evidence, we take it that there is prima facie evidence. But if you say that that was the wrong test...
Yes. So, in fact, I think we are together. The criticism... If you don't want me to comment, let me know, Justice Rogers, if you don't want me to comment on the 2 paragraphs that Justice Madlanga referred to.
Perhaps let me just finish and then you can come back and comment on those 2 paragraphs. Yes. We then find that the $580,000 is not put into a safe, and I would have thought more importantly, it is not put into a bank where it would have earned interest at about 2,300 Rand per day. The first thing anybody who receives 8.7 million Rand wants to do is to make sure it goes into their money market account. You don't leave that much money, sorry, I'm now speaking as a matter of common sense. You don't just leave that money either in a safe or under a sofa. I'm not talking about, it's common cause that it wasn't banked and it was hidden in a sofa.
Yes. Well, the question is, what is the role of the members of parliament in relation to what the president knew at the time?
Well, if they read the whole report, because the structure of the report is before the committee starts dealing with the individual charges, which starts at paragraph 181,
Yes.
where it starts with charge 1. It's had what seems, in the context of its report as a whole, to be a very important chapter 12 that runs from page 89 through to 173, including the conclusion in paragraph 171. And that's all to do with the source of the money. And it is clear from the panel at least believed on the information that had been submitted to it that it did not accept that the money had come from the sale of buffalo.
Yes.
Sorry. And then having considered the individual charges, it then in chapter 15 deals with the seriousness of the violation and the misconduct. And it is at that point that it ties in chapter 12 with charges 2, 3, and 4. To reach a conclusion, call it a prima facie conclusion,
Yes.
that the reason why there wasn't a report to the DPCI and the reason why a case wasn't opened and the reason why General Rueda, as it were, off books, conducted an investigation and into the theft was because the source of the money was not legitimate. There was an attempt being made to conceal that was the case.
Yes.
Now, I assume you accept that if there was, let's just say, prima facie evidence of that would be prima facie evidence of extremely serious misconduct.
Yes. I have no difficulty accepting that at all.
And do you say that there was prima facie evidence of that, but not sufficient evidence?
Yes. No. I think this is where you and I, Justice Rogers, do not seem to be getting what I'm trying to say. I am saying the finding that must be made by the panel is sufficient evidence. If the panel erroneously fails to make that finding, that is sufficient to vitiate its report. And that is why I've taken the court to where the panel makes that finding. So my primary point is from the perspective of the MPs that were voting on the report, what they needed to look at, which is what was debated, did the panel act in accordance with its terms of reference? Its terms of reference required it to conclude sufficient evidence. Did they do that or not? They came to the conclusion that it didn't. And on that basis, they said we could not correct an illegality with another illegality. We would vote down the report. Now, it may be that one day, in a criminal case, the president will have a case to answer. It may be that one day, in a different case that comes before the National Assembly, the ANC will take a different position. But on this report, in these findings, the National Assembly was perfectly rational in arriving at the decision that it did.
Now, the expression prima facie evidence does still refer to evidence, but you say the fact that it is prima facie stands on a different footing from its being sufficient.
Indeed.
Now, in the context of the report as a whole, if one reads what the panel regarded as the evidence, and you say, but it formulated it as being merely prima facie, but if you look at that evidence, and you say that although it called it prima facie, it was within the context of its function under Rule 129I sufficient, bearing in mind that it's not, as you have said, a veracity exercise. The context is it enough to go to an impeachment committee? What would you understand the precise difference to be between, let's assume for the moment it amounts to evidence, it amounts to prima facie evidence as opposed to sufficient. What do you say is the lower test which has been impermissibly slipped in?
The distinction is better explained by reference to the rules themselves. If you go to page 631, at Rule 129A, and 129A1 sub A.
Sorry,
129 capital A, brackets 1 small a.
Yes.
So the rule itself tells you that when the speaker decides whether or not to constitute a Section 89 panel, she must already apply her mind to whether the charge sheet contains prima facie, what discloses a prima facie case against the president. But that changes fundamentally when you go to 633. Sorry, no, it should be 633.
Whether sufficient evidence exists.
Yes, whether there's sufficient evidence that exists.
Yes, now, sorry.
Yes. Now, what that means is that it is not up to the court, and it is not up to the assembly. It is up to the panel to come to the conclusion that sufficient evidence exists. That's number one. Number two, we know here, we don't speculate. We know precisely here that they did not intend to do what you are suggesting, Justice Rogers, because they specifically debated the difference, and they ultimately came to the conclusion that there is no difference.
There is no difference.
There is no difference. That is the conclusion.
Yes, but that was my question. What is actually the difference? Bear in mind, what the Speaker does when she or he vets the motion is only looking at the evidence put up by the party moving the motion. That's the only evidence at that stage.
Yes.
That's one side.
Yes.
By the time it gets to the independent panel and it reaches its conclusion after it's gone through all the processes it must go through, it has also heard the President's version.
Well, we can...
Now the question is, in the light of all, and bear in mind, it is no longer the Speaker who is, as it were, doing a first cut, and the Speaker may, with due respect to her or him, not have any legal qualifications.
Yes.
That same evidence, plus any additional evidence that has now been placed before the committee, plus the President's response to it, all of that, is there sufficient evidence? Now, all of that has been considered. Now, in the context where you have not now only heard one side, but you've received additional information supporting the motion, and you've received additional motion against it from the President, now you say, in the light of all of that, the formulated test is sufficient evidence. But what I want to know is, what is a lawyer conveying when they assess all of that evidence and they describe it as prima facie evidence rather than sufficient? What is the qualitative difference that you would then understand between those two formulations?
Well, the first thing we would know for sure is that they did not do what they were asked to do, which is to consider whether there is sufficient evidence. We know that as a fact. They specifically disregarded their terms of reference. And in fact, Justice Rogers, you reminded me of something else. We found the actual terms of reference. They are in the SLA. We tried to submit them. There is an objection from the EFF. But it's important for the court to know the actual terms of reference that the panel had. If the court is interested, we would be happy to circulate those, but we've now got them. So we know for a fact that they disregarded their mandate. They were told they must find, positively find, not hide it in another language, positively find. And that is because, and this is important, that's why it's not a terminological problem. It's important because you're going to send this to lay persons, 400 of them, and you're going to ask of them to make a decision. And what they will have in front of them is they will have the terms of reference they gave you and your report. The first thing that will be glaring is that you disregarded what they asked you to do.
What Toby was trying to defend, but Judge Rogers didn't miss no words about the Phala Phala scandal, what Cyril Ramaphosa did. Because it seemed Ramaphosa was doing his own investigation on the side. He didn't want anybody to know about it. So I just want I come with this video here just to upload what EFF has done, because EFF and ATM, they might be looking like a small party, but the impact of them being in parliament, doing what they are doing, it's remarkable. Because ANC is always voting in parliament high. That's why now ANC has lost, getting 39% under Cyril Ramaphosa. Now they have the collusion with the DA because of the corruption that is in the ANC. We might hate EFF, we might hate ATM, but what they are doing in parliament, if say today they are not there, there is no EFF, imagine what it will be like to have that kind of a parliament, that nobody is held responsible for whatever. It can be a banana republic. We like it or not, whatever EFF is doing in parliament, it has changed the politics of South Africa to be what they are today. Family, what do you think? What's your comment about Rogers? It looked like it was a joke when he was talking about this Phala Phala thing. But it was not a joke. Though Toby felt like he was cracking a joke. He was not cracking a joke. It's a serious case. And it's just as because people laughed in the court and Toby didn't feel comfortable about that. It was embarrassing for him. But the fact is, Rogers was taking the bull with its horns. He didn't want to miss no words. He just said as it is. Family, what do you think about this? Drop your comment. Don't forget to like and share. And turn the notification bell on.